Yes, Mr. Lee.
My lords and my lady, I, along with Mr. Stuart Parker, appear on behalf of the appellant, and my learned friends Mr. Randall, King's Counsel, and Mr. Mundy appear on behalf of the respondents. This appeal concerns the findings of Deputy Judge Halpern, King's Counsel, who I will refer to as the judge, in respect of the appellant's intention to create a trust of his shares in a company called Jeeves Estates Ltd, which I'll refer to as JEL, or the company. As your lordships and ladyship will no doubt know, the lordship found that when the appellant received his 100 shares in JEL by November 2007, he intended to hold those shares on trust for his grandchildren. The law identified by the judge in this regard, and the question that he posed to himself, was whether the appellant's words and conduct, viewed in the context of the surrounding facts and matters, showed a clear intention to make a disposal of the shares in question, so that the alleged beneficiaries would acquire a beneficial interest. And that is taken from the judgment, which is found in the core bundle at tab 12, page 133, at paragraph 124, subparagraph 1. The judge rightly treated the appellant as the putative settler, whose intention it was relevant to determine, and he identified the correct test to be applied by reference to this court's decision in Paul and Constance. However, the appellant maintains that he then misapplied that test to the facts as he otherwise found them. Thus, the two key issues in the present appeal are, one, what Lord Justice Scarman, in the case of Paul and Constance, meant when he held that there must be clear evidence from what is said or done of an intention to create a trust. And two, was that test satisfied on the evidence in this case?
Yes, well, can I just intervene to do two things? One is of interest to me, arising from what you just said. But also the other thing is just to consider the timetable for the hearing. We've been given quite a generous time estimate, and I really just wanted to say that the time is there if we need it. But if you find that we don't need it, we're not going to be disappointed.
Indeed.
But the argument will take its course. But if it proves that we can finish in a day, then I'm sure that parties would be glad of it. So let's see how we go.
I'm grateful for that, Arnold.
The second thing, which I'm sure is for my education and not that of my lady or my lord, is when we're talking about evidence of words and actions showing a clear intention to make a disposal, do those words, if it's an express declaration of trust, have to be spoken at the time at which the trust is created?
Of course, my lord. In fact, perhaps the
well, I'm really. It's really in order to avoid things like, of course, that I'm asking you the question, because I want to be want it explained to me whether, in order to establish an express trust orally, one has to say something at the time that the trust is declared, as opposed to something said later which might cast light backwards. Does it, in the end, in order to satisfy the test, whether it's in Paul or Constance or anywhere else, it'd have to be the case that the court would have to find that something was said at the time?
My lord, I can answer that question by reference to the decision of the Supreme Court in Gani, and that's found at the authorities bundle, tab 17.
Right. Please don't let me take you out of your course, but if it's convenient to look at that now, that's in my mind.
Absolutely, because it in fact, this in many ways frames the point in the appeal.
Right. Tab 17, yes?
Tab 17, and it's page 243 of the bundle.
Could you say that again?
243.
Thank you.
Of the bundle. Privy Council, I'm obliged, not Supreme Court.
Yes.
And at paragraph 17, Lord Briggs notes that it was convenient to begin with a restatement of the basic principles. This was a case in which there was a gratuitous transfer from a father to a company, that in previous instances he had gratuitously transferred assets to the same company as a trustee expressly. But in the instance relevant to this case, there was no express explanation as to why or on what basis he transferred those assets gratuitously. And so the question before the Privy Council was whether the company in question, Gani, took the assets beneficially or took the assets on trust on the same terms as it previously held the other assets. And he Lord Briggs first says that if the transferor or transferee makes a written or oral declaration as to those beneficial interests, or they do so together in agreed form, that will generally be decisive, regardless of the subjective intentions of either of them. So the first point is to look for a written or oral declaration of interest. And of course that would almost undoubtedly have to be at the time. But secondly, and in default of any such declaration, the court looks for evidence from which a common intention as to the beneficial ownership may be inferred, and this may include evidence of statements made by either party before, at the time of, or even after the relevant transfer, the party's conduct, and the factual context in which the transfer takes place. And then he goes on to say sometimes a choice between possible conclusions as to the beneficial interest may properly be arrived at by a process of elimination, whereby the most unlikely conclusions are first removed, leaving the least unlikely as the correct one. And then he finally says recourse after that may be head to time-honoured presumptions. So, my lord, you can see from that that the first stage of the exercise is to identify whether there is a written or oral declaration as to the beneficial interests. But if there isn't, then the court may go on to consider the words and deeds of the putative settler, not only before and at the time of the transfer, but also after.
Right. So the fact that the judge in our case did not make a finding that in 2005 or whenever it might be, the appellant made a statement indicating a declaration of trust. That is not a fatal flaw in the reasoning. It's still open to him by Lord Briggs' second route to arrive at the conclusion that he arrived at. You challenged that, but I just wanted to fit that particular...
But precisely, my lord. The fact that the judge had recourse, and in fact solely had recourse, to actions and conduct after the alleged date the trust was established, does not undermine the veracity of his judgment.
In particular, it's not a situation in which he would be using the later statement, such as I'm holding it in trust for now, or whatever it was, in order to say there must have been a statement orally made at the time. That's not the search that is being undertaken here.
My lord, no. Now, this may be a point in which there is disagreement between myself and my learned friend, because I have observed in his skeleton that he has paraphrased the judge in saying that the judge found that Mr. Gill, the appellant, agreed in 2006 to hold the shares on trust. Now, my lord, I would say that's a misreading of the judgment, and I'll get onto that in
But in a sense, you're in effect conceding the point that I was raising, which is that whatever flaws there may be in the judgment, one of them is not that the judge was bound, if he was making the decision he did, to find that there was a conversation of some kind back in 2005-06.
Precisely.
That's
precisely.
Very helpful.
What occurs is where there is no evidence, as in this case, as to what exactly was said and done at the time of the transfer, the court may have regard to the words and conduct of the parties thereafter, effectively to objectively decide whether a trust was declared at that time, at the earlier time. Now, one point before I move on from your lordship's question, and I will address your lordship and ladyship in more detail on this in due course, but there is, I would submit, a written declaration of the appellant and the other shareholder in the company, the second respondent, in writing as to the beneficial interests in the company, and that is the option agreement. But, of course, I have to concede that that option agreement was entered into some years after.
It's 2011.
It's 2011, my lady, yes,
Yeah.
precisely.
And the judge deals with that and says how he thinks it fits in.
Yes, my lady. So the judge, and indeed this is a point I'll develop in due course, but the judge found that the option agreement was more consistent with the position that Mr. Gill held the shares beneficially. And in fact went on so far as to say that it makes little sense, I think was the exact phrase used by the judge, if the appellant held the shares on trust. So he certainly made those findings as regard the option agreement. However, when he comes to then assess the totality of the words and deeds of the appellant, applying the test in Paul and Constance, he then ascribes it effectively little weight. He says that it's insufficient to overcome what he considered the matters pointing towards a declaration of trust.
Not sufficient to outweigh the other factors. That's paragraph 141.
Precisely, my lady. Precisely, my lady. So just again, starting with the sort of framework of how I'll develop the submission, subject to your lordships and ladyships' questions. The two key points are what Lord Justice Scarman meant in Paul and Constance as there must be clear evidence, and whether that test was satisfied in the present case. Now, in refusing permission to appeal, the judge treated the issues in this appeal as factual questions. He in fact said in relation also to ground one, even ground one, that this was fundamentally a question of fact. And whether or not the appellant had a particular intention to create a trust, he treated simply as a factual matter for him to decide on the balance of probabilities, and once so decided, he appeared to consider that the decision could not be challenged unless the normal requirements of factual appeals, such as those set out in the sprint room, were established. Now, the appellant submits that that was wrong, and that the true position is that the question that the judge had to answer in this regard was one of mixed fact and law. It is, of course, correct that a trial judge must determine what was said and done by the putative settler, and not only at the time of the trust, if it's possible, unlike in this case where it wasn't, but also subsequently, as the question from my lord has already demonstrated by reference to Gannon. And those are factual findings that can only be appealed as facts, subject to the normal rules of appeals of fact. And grounds 2 and 3, as I'll come on to, are unquestionably appeals of fact in that regard. However, once a trial judge determines what was said and done by the putative settler, the court must assess those facts and decide whether or not they demonstrate a clear intention to create a trust on an objective basis. It is not purely a factual exercise, but involves a legal exercise akin to the construction of a contract. The appellant's position is that this court is in as good a position as the judge to determine whether the facts identified by him and relied on by him in coming to his decision objectively satisfy that test of clear evidence. And of course, the appellant further submits that when properly considered, the facts relied upon by the judge were not so sufficient. Dealing briefly with the 4 grounds of appeal, it is ground 1, which is the principal ground, where the appellant challenges the judge's conclusion that the appellant intended to create a trust, and that is the ground where the issues I've just outlined are raised. Grounds 2 and 3 arise only if the court does not agree with the appellant's position on ground 1. Ground 1 I will approach, as you will see, on the basis that you take the facts as found by the judge, and I do not challenge them. If the judge's reasoning is wrong on the basis of ground 1, there is no need then for me to go on and establish that he made errors of fact. So grounds 2 and 3 only arise if I do not satisfy your lordships and ladyship on ground 1. But by ground 2 and 3, the appellant seeks to challenge as appeals of fact certain findings of the judge. And no doubt you will have seen that the judge himself recognized that his finding was on a narrow margin. And that is why it's the appellant's position that if only one of the appeals of fact is successful, that would render the judge's conclusion unsafe. Ground 4 concerns the judge's alternative finding of a resulting trust. And so this ground necessarily will only arise if the court is satisfied that the judge's primary holding as to the appellant's intention is wrong. This morning, therefore, I will address these issues on the following timetable. First, I'll make submissions as to why this is an appeal of law on ground 1, not an appeal of fact. Secondly, I'll address the substance of ground 1, namely why the judge erred as a matter of law in finding that there was clear evidence. And then I will go on to address grounds 2 and 3 together, along with my learned friend's case, that other factual matters that he contends the judge ought to have been given more weight.
That's the respondent's notice.
That's the respondent's notice, my lord, yes. And finally, I will deal with ground 4 on the resulting trust.
Thank you.
So firstly, ground 1, is it fact or law? The starting point is the decision in Paul and Constance, which is found in the authorities bundle at tab 2, page 22. And this is the holdings. In the holdings, you'll see that it is described that to create a trust by an express declaration, the disponee's words and actions had to show a clear intention to dispose of the property so that someone else should acquire the beneficial interest. And that I would submit, is the legal test. Then within the judgment, page 26 of the bundle, at G, you will see there that Lord Justice Scarman sets out the submissions of counsel. And they include that there must be a clear declaration of trust, and that means that there must be clear evidence from what is said or done of an intention to create a trust, or as the counsel put it, an intention to dispose of a property or fund so that somebody else has to the exclusion of the disponent acquires the beneficial interest in it. Then in H, you'll see that Lord Justice Scarman concludes that he thinks that the evidence does have to go that far. So he agreed with counsel's submissions in that regard.
What do you say about what Lord Justice Scarman said right at the foot of the page? The judge, rightly treating the basic problem in this case as a question of fact, reached this conclusion.
Yes, so my lord, he says that at the bottom of H, and then over the page he says it again between A and B. In this context, in this court, the issue becomes: was there sufficient evidence to justify the judge in reaching that conclusion of fact? Now, my lord, I entirely agree that that suggests that this is a purely factual point, and on the basis of those words alone, this court might well say that I'm simply wrong. But there are 3 points that I'd say to that. The first is that, in fact, when you look at the way Lord Justice Scarman approached the decision and the question, he did not apply the test that one would normally apply in this appellate court for questions of fact. He effectively looked at the evidence in question and decided the point de novo. Now, he agreed with the judge, but he at no point said that the test to be applied was one of the factual appeal. The second point is from this judgment, which is that Lord Justice Bridge puts the point slightly differently. And you'll see at H on page 2532, page 27 of the bundle, he says, in the last analysis, accordingly, the whole question in this case, as it seems to me, is whether the judge was right construing those words according to their proper meaning and in the context in which the words were spoken, as disclosed by the evidence, to conclude by using those words the deceased had done something which was equivalent to declaring himself a trustee of the monies in the account for himself and the plaintiff in equal shares. So you'll see, my lord, there Lord Justice Bridge describes the process far more as one akin to construction. The third point, I'd say, is that subsequent cases have approached the matter using an objective test, using the test of what a reasonable man, a reasonable bystander would consider, viewing the facts as found by the judge. And the first of those cases is On and Ping.
Sorry, but to interrupt, before you go on though, I mean, the issue with which Lord Justice Scarman was grappling on page 27 of the bundle 532 of the report is whether a statement, because they had the statement in that case, so it's a different scenario from the one that we're concerned with, and he's grappling with whether a statement like this money is as much yours as mine, in the context in which it arose between people whom he describes as unsophisticated, was sufficient to be a clear declaration of trust. So actually, what he was doing was a different exercise.
Well, my lady, you're absolutely right that what he was doing was effectively construing words. He was taking the words said by Mr. Constance and construing them to determine their true effect. And we'll see in On and Ping that it's more expressly described that this is effectively similar to construing a contract, where it's not the subjective intent of the party making the words that's important. What's important is how those words would be construed by an objective bystander, the reasonable person. But my lady, I would submit that the precisely same exercise was conducted by the judge in this case, because although...
Well, I'm sorry, before you get into the facts of this case, can we just go back for a moment to Paul and Constance? Because what Lord Justice Scarman went on to do at 532, it's really at C to D. He says there are, as Mr. Wilson reminded us, other features in the history of the relationship between the plaintiff and the deceiver which support the interpretation of those words as an express declaration of trust. Now, pausing there, that supports what you were saying about it being a question of interpretation. But then he goes on to say, I've already described the interview with the bank manager when the account was opened. I've also mentioned putting the bingo winnings into the account. So that seems to suggest that it's a factual evaluation in all the circumstances, doesn't it?
Well, my lord, it is certainly an evaluation in all the circumstances, in the sense that the question, as set out in Gani, and indeed in Paul and Constance itself, is not just words used. It's not construing just the words used. It has to be construed within the factual matrix as found by the judge and the other deeds, such as in this case, the deposit of the bingo winnings in the bank account. But nonetheless, when the court considers all of those factual findings, it is effectively construing how those words and deeds operate on an objective basis. And we'll see in On and Ping that the test is that the reasonable person, not just hearing what the putative settler said or seeing what the putative settler wrote, but also taking into account what the putative settler did, would that reasonable person have concluded that the settler intended to create a trust? And I would submit that it's that objectivity, it's that objective element of this test, using the artificial construct of a reasonable person who, of course, doesn't exist and wasn't present. It's not a question of fact. It's actually a question of a legal test of objectivity, which has to be reached on the facts.
Can you help me on this question? You've emphasised a number of times that it's an objective question, and I wouldn't imagine that's in dispute. But why does that differentiate it? It's an objective question, whether you view it as an issue of fact or an issue of law, isn't it?
The objective element of it, my lord, is, I'd say, an important differentiating factor, because it places an appellate court in a very different position than it would be if it were a purely subjective test. Because if the investigation were purely to have regard to the subjective intent of the putative settler, that is undoubtedly a question of fact. He had that intent, or he did not have that intent, and that is a subjective point for the judge to conclude. But what the objectivity does is it brings into a standard that must be met when weighing all of the evidence together.
I'm sure it's my fault and I'm missing the point that you're making, but let's take an analogy, which is an oral contract. So it's an objective question as to whether the words spoken amount to an agreement.
Yes.
The court doesn't inquire into the subjective intention of the party speaking the words.
Yes.
But it's still a question of fact.
Well, my lord, it's a question of fact that is subject to that objective test. So when the appellate court comes to view the question, the appellate court can look at the facts relied upon by the judge in coming to the conclusion to decide whether or not the objective test has been fulfilled. Put it this way, my lord, it is not a question of the weighing of oral evidence or the consideration of a particular point raised by a witness in the witness box. One can't cross-examine the reasonable person. It's something that the court creates, a standard the court creates to test against the facts as found.
Thank you.
And so you're saying that, are you, that it was essential, obviously, to weigh up all the facts about what happened and the conduct, and what the parties intended was subjective, and that was also for the judge to glean, let's put it that way, from the evidence that he heard. So he concludes, this happened, that happened, the conduct was this and that and something else. And it's clear to me from all of that they intended to achieve X, a declaration of trust or whatever. But then there's an overarching, immutable standard, which is that nevertheless a declaration of trust?
Well, my lady, I don't think I'd necessarily put it in that sort of two-step process, because where the judge does not, as in this case, have a clear declaration in writing or orally at the time the trust was created, the judge must weigh the evidence after the declaration, as the judge did in this case. And the test is not, therefore, did this particular putative settler subjectively intend to declare a trust? The test is, would an objective bystander, having regard to the putative settler's words and conduct, have concluded that he had that intent? And my lady, I think it's an important distinction, because you can see, indeed, from the facts of Paul and Constance itself, how this operates. Lord Justice Scarman, earlier in the judgment, using slightly outmoded language, referred to both Mr. Constance and Mrs. Paul as simple people. They were not sophisticated individuals. And so if one asked Mr. Paul, at the time he opened the bank account and he put his recoveries from the lawsuit into the bank account, do you intend to declare a trust, or do you intend to depart with his beneficial interest? One would likely assume that he'd say, what's a trust? What's a beneficial interest? You know, he's not a sophisticated individual. So it's not actually looking at the subjective intention. What the court needs to do is find, as a matter of fact, what Mr. Constance did and said, and then apply the objective standard as to whether or not... Yes, precisely. And indeed, my lady, I think that the same point could probably go conversely, where one can imagine circumstances where an individual may very well wish a trust to exist. For example, a trust set up perhaps to minimize tax. And so the subjective intention of the individual may very, very well that a trust is to be intended. And if you ask him at the time, do you intend to create a trust or part with the beneficial interest, he may gladly say yes. But I would submit that's not where the court stops. Because if then, after that, saying those words, that putative settlor effectively treats the money as his own thereafter and doesn't act as a trustee at all, then the court may well come to a conclusion that despite his subjective views as to what he intended, a reasonable bystander would actually come to a different conclusion and say that he didn't intend to part with the beneficial interest in the property. So it's that nature, that objectivity of the test, which I would say makes it amenable to appeal. I suppose precisely whether it's classified as fact or law is perhaps of less importance than the fact that this court is in as good a position as the judge to decide the point, because this court can look at the very facts and matters relied upon by the judge in coming to his conclusion and can test for itself whether that's objective standard is fulfilled.
May I return to the point that I asked you about earlier on? The judge here made a finding of an express declaration of trust.
Yes, well, he found that an express trust had been created.
Right. An express trust had been created.
Yes.
Right. What is the what then is required for an express trust? It's either writing or words.
Well, for an express trust, you have to have the three certainties, which are certainties of intention, subject matter, and objects. And obviously, this appeal doesn't concern the latter two. It's purely the certainty of intention. And so what the judge had to do was determine whether at the time the trust was said to have been created, there was the certainty of intention. And we can see in Gani that where a court is unable to point to specific words said leading up to or at the time of the transaction, the court looks to...
Yes, so that's evidential. But what the court is looking for, you say, is certainty of intention.
Yes.
In order to arrive at a conclusion of, let's call it an express trust.
Yes.
Does that imply that an express trust can be created without any outward manifestation?
Well, my lord, I would say not, because if you have no outward manifestation whatsoever, then the court obviously would not have a document to construe.
Well, I mean, we know that at some point the shares were placed in the name of your client.
Yes.
So that was an outward manifestation of something.
Yes.
But what I'm just trying to clarify in my own mind is whether it's right to assume that if you're going to have an express trust, then somebody must have said or done something, must have said or written something at some point to show the expression of their declaration of trust, or whether that is not a requirement in some cases also.
Well, my lord, I would say that's a requirement in all the cases, because one can't have certainty of intention unless there is some outward manifestation of that. And plainly, the most common outward manifestation is some form of written declaration. But if you don't have a written declaration, and then you have no words or conduct that manifest an intention to create a trust, then the reasonable bystander would not conclude that there was such an intention.
Would I be right in thinking that you accept that the requisite intention may be demonstrated by a combination of words on the one hand and conduct on the other, even if, taken in isolation, neither the words on their own nor the conduct on its own would suffice?
Yes, my lord. Yes. It's not words or conduct in the sense that you only look at words and you only look at conduct, it's together. And in fact, On and Ping is an example.
The reason why I was interrupting, because I know we're about to go into some cases, and I'd just like, if you wouldn't mind noting as we go through the authorities, whether there are other cases in which statements are being made in what is effectively an evidential vacuum, as it were, at the time itself. That there is no evidence in this case relating to 2005-2006. Do you follow my point?
I do follow you.
I mean, because in other words, what we've just been looking at, Paul, is a case where something was said.
Absolutely, my lord.
So when we go through these, I'd just like to understand whether there are other cases that we're going to be shown where, in effect, there is this absence of evidence.
We'll go through the cases.
Beginning.
My recollection is that there were manifestations in Ping and North and Wilkinson and Hosnier, which are the three cases I was going to take your lordships and ladyship to.
So this case is you may be submitting somewhat different to them on the facts.
Well, it's different in the sense that there's even less certainty, because the judge in this case had to rely solely on the conduct after the declaration of trust, and so it necessarily is less reliable and less certain than the cases where there is an outward manifestation at the time the trusts were created.
Right, thank you. So what section are we going to now?
The decision of On and Ping, which is at 40 bundles tab 15.
Thank you.
And this is a decision of the Court of Appeal of Hong Kong. And Sir Colin Rymer gave judgment with which Sir Brian Levison and Lord Justice Underhill agreed. And following up on your lordship's question just now, this is a case where there was a written document. And it was argued on appeal that the wording of the document in question meant that the trust did not include all of the assets found to be held on trust by the trial judge. And for your lordship's and ladyship's reference, that's from paragraph 41. But the point that I'd like to take your lordship's and ladyship to is at page 224, judgment, paragraph 58. And you'll see that here Sir Colin Rymer rejected the submissions that the written document in question did not mean that the assets of the trust were held on trust. But he had regard not only to the document itself, but also the conduct of the putative settler, namely correspondence.
Do you want us to read a passage from this?
My lord, yes, it may be helpful.
Which paragraphs?
If you could read paragraphs 58 and 59.
Thank you. Thank you.
So, my lords and ladies, you will see here that the test applied by Sir Colin Rymer, and I should pause. I don't know why it was a Hong Kong Court of Appeal. My learned friend has brought to my attention it's actually the English Court of Appeals. It is. Yes, it is this court, yes. But you'll see that Sir Colin Rymer applied the test of the reasonable person. So the way that he dealt with the matter, not just by looking at the document, but also the correspondence of the putative settler, he applied the test of what a reasonable person would have concluded from that conduct. And again, similar to the decision of Lord Justice Scarman in Paul and Constance, there is no indication in Sir Colin Rymer's judgment in On and Ping that he is applying the test akin to as held in Sprint Room as to the challenging the facts held by the judge.
But it might be said that that's because the nature of the case being considered was one purely of inference from documents. So there was the execution of the settlement, which wasn't in dispute, and then there was what was said in the correspondence, and that wasn't in dispute either. What was in dispute was what inference you could draw from those matters.
Well, my lord, two points to make in relation to that. The first, which is the next case I'll take you to in Wilkinson and North, Lord Justice David Richards didn't draw a distinction in applying this test between documents, words, and conduct. But also, my lord, here you are in a very similar position, because whilst there is conduct and words said orally, those are all accepted in this Court of Appeal under Ground 1. So it is a question not of you as the court factually deciding what was said. It's a question of taking what was said and construing it. And for a good example is the comment "for the moment," which obviously I'll get onto in more detail in due course. But there, the exercise your lordships and ladyship are undertaking today is not to determine whether or not those words were said, but instead to construe what those words meant. And I would actually, on that point, if you turn to tab 16 of the authorities bundle, which is the decision of this court in Wilkinson and North, at page 227, I'd be obliged if you could read paragraph 2 of the decision of Lord Justice David Richards. So, my lords and lady, you will see that paragraph 2, Lord Justice David Richard observes that the intention must be determined objectively, and he says by reference to documents, words, or conduct. So the test is applied equally to documents, words, and conduct. And indeed, as my Lord Justice Arnold mentioned earlier, Lord Justice David Richards draws a parallel with the approach adopted to determine whether a contract has been formed. And the final case that I'll take your lordships and ladyship to is at tab 18, which is an appeal in the Chancery Division and a decision of Mr. Justice Morgan in Hilton and Cosnia. And at page 263, paragraph 21, he refers to both Paul and Constance and On and Ping. And at paragraph 22, he said that accordingly I must ask myself whether the oral statement amounted to a clear declaration of trust, and whether that statement is clear evidence from what was said of an intention to create a trust. So again, there is no suggestion here of the appellate court needing to be satisfied to overturn a trial judge's conclusion on facts. Here the question, which I say is the question that this court must ask itself, is whether the oral statement and indeed the conduct referred to by the judge amounts to a clear declaration of trust. And before I move on from this first point, if indeed this is purely a factual issue to which the normal factual appeal rigors must be applied, it's very difficult to see where Lord Justice Scarman's clear evidence comes in at all. Because my learned friend and I are agreed that the standard of proof is, of course, balanced probabilities. And there is no heightened standard of proof in civil proceedings. And so the question, if it was purely a question of fact, would simply be, did the judge take the view on the balance of probabilities that the appellant had the requisite intention? And in my submission, if that were the sole test, there'd be no room for clear evidence. Clear evidence wouldn't even come into it. It is simply otiose. And that is why I submit that Lord Justice Scarman, as has been applied in these subsequent cases I've taken, Your Lordships and Ladyship too, it is not just a question of balance of probabilities, but it is a question of an objective standard against which both the judge and this court effectively apply a legal test.
Right. So is that point one?
That's point one, Mike.
Thank you very much.
So point two then is whether or not on the facts as found by this judge, one can say that there is objectively clear evidence of an intention. And this is not a case where the appellate court has to search hard within the judgment to identify those facts on which the judge predicated his decision, because the judge outlined them starting at paragraph 139, which is in the core bundle tab 12, page 135. If Your Lordship and Ladyship could read paragraph 139. So the first fact that he relies on in this regard is the oral comment by the appellant, many years after the supposed establishment of the trust, that he held his shares for his grandchildren, quote, for the moment, unquote.
That was 2018.
That's 2018, my lord, yes. And the judge says that this, quote, tends to suggest that he regarded himself as a trustee, unquote. Now, my lords and lady, although this statement was made many years after the putative trust was created, this is an important statement because it is one of just two examples of words actually used by the appellant in relation to these shares. And the other example is the option agreement, which I'll address you in due course. Regarding the comment for the moment, simply put, it is completely inconsistent with an intention by the appellant to dispose absolutely with his beneficial interest in those shares. And the judge himself found so, I would submit, earlier in the judgment. If Your Lordships and Ladyship turn back to page 130 of the bundle, paragraph 102, there the judge noted that it was not clear what the appellant meant by those words, entirely clear, and that it tended to suggest that he regarded himself as, quote, currently holding, unquote, the shares for the grandchildren. Only currently holding. That is not consistent with a trust, which is imperative and absolute. As Your Lordships and Ladyship have already read, Lord Justice David Richardson Wilkinson, in paragraph 2, noted that trusts generally have irreversible consequences. And there is nothing to suggest in this case that the trust created was anything but irrevocable. The phrase, for the moment, is consistent with the appellant holding the shares for his grandchildren at the time he made the comment, as the judge found, currently hold them, but is inconsistent with an intention on his behalf that he had disposed of his interest in those shares absolutely. It necessarily meant that he retained an interest and ability to not hold them in the future.
One can also read 102 together with 139 to suggest that the currently holding the JEL shares means that that was his understanding of the position at the time. Meaning Mr. Gill's
Yes,
understanding of the position.
my lady, I can
at
see
the
that
time.
the words currently holding used by the judge could mean that. But that
especially
is not,
when you look at it in relation to 139 and he refers himself back to 102.
Well,
it's not that he'd forgotten 102.
my lady, yes, but that is inconsistent for the moment. Because the words for the moment, if he meant currently holding as simply saying, well, I am a trustee and I'm currently holding these assets, that obviously is consistent with trust. But for the moment, in my view, cannot be construed in that way. Because for the moment is not a declaration of a set of facts at this particular time, but it is also looking forward, at least impliedly, that that situation may change in the future. And indeed, that was a point that the judge, I think, did appreciate, because he at one point referred to this as potentially a threat. So there's within the phrase "for the moment" an understanding that Mr. Gill retained the ability to not hold the shares of grandchildren.
Where did the judge say that? I know the respondents have made that suggestion, but where did the judge say that?
My lord, my recollection is that he did. What I'll do is I will not take the time here, but I'll get my learned friend, Mr. Stuart Parker, to look for that reference and give it to you.
Thank you.
But if you say something is for the moment, it doesn't tell you necessarily very much about how far back that state of affairs has continued. So one might say, I'm in such and such a set of chambers at the moment, or for the moment, that you will have been there for some period of time up until now, and you may be saying, I might not be staying, I might change it. But so is this not equally consistent, for example, with Mr. Gill saying, well, I may be holding them on trust, but I'm going to try and get out of it in the light of what's happened to this family?
Well,
I mean, not knowing that he might not be able to get out of it. I mean, for the moment, it seems to me pregnant with all sorts of different possibilities.
well, my lord, I take that point, but I think that in some ways at least emphasizes part of my submission, which is that when one is looking for clear evidence of intention, these words are not clear. You know, taken at its very least, I'd submit that they do not tend.
No, certainly taken on their own.
Absolutely, my lord. Yes.
Yeah, I mean, I have no difficulty with your submission about that, because I've just made a rather similar point that it can mean a number of things.
But when we're looking at these words, my lord, at least one viable construction, and I would submit is the correct construction, is that it has within it no intention to permanently part with the beneficial interest in the property. Because taking your example of someone in chambers, it necessarily implies that you might leave those chambers in the future. And that is inconsistent with trust. Because with trust, he will never hold those shares for himself. He'll either not hold them at all, because he'll resign as trustee, or he will always hold them absolutely for the beneficiaries.
You may have had some assistance from behind.
Oh, thank you.
Thank you. Yes.
So, my lord, I would say that the first piece of evidence relied upon by the judge does not objectively support an intention on the appellant's behalf to dispose of his interest in his shares absolutely. I would say quite the opposite.
Can I ask you a different question about paragraph 102? It's this. If one looks at the judge's finding, it's the second sentence of paragraph 1, is it? And what the judge says is, he says, that's Mr. Basu, that he, Mr. Basu, told Mr. Gill that Mr. Gill held the shares on trust for all his grandchildren, to which Mr. Gill replied, for the moment. Now, I perfectly understand that your submissions focus on the words for the moment, and I understand why you place importance upon those words. But can I just ask you a question about what the judge has found prior to that? Because as I read it, I think what the judge is saying there, or what the judge is placing reliance upon, is the absence of a denial from Mr. Gill. In other words, Mr. Basu, on this account, which the judge has accepted, has said, you're holding these shares on trust. And what the judge is placing weight on, I think, is the fact that Mr. Gill's response, and the judge accepts this, is for the moment. And one can debate the meaning of for the moment, but what the judge is relying upon is this is not a denial.
Well,
what would you say to that?
That is undoubtedly correct. But when looking at the appellant's words, they are simply inconsistent with the statement. So, there is actually a denial here, in the sense that it has been put to Mr. Gill that he is a trustee of these shares, and then he has said something completely inconsistent with holding the shares on trust. Now, it's obviously not as clear as if Mr. Gill had said, no, I don't hold them on trust.
But you say that for the moment is a denial.
Effectively, yes, because it is inconsistent with holding the shares on trust. And as Lord Justice Scarman noted in Poem Constance, another way of phrasing the test and intention to create a trust is, of course, an intention to dispose of the beneficial interest in the property. And when the test is looked at like that, for the moment, is particularly inconsistent, because it doesn't have the absolute nature of disposing of the beneficial interest.
But it could equally be, but I want to stop being the trustee.
It could be that, but it would mean that he wouldn't hold the shares at all. And
No, I'm meaning for the moment means, yes, I am, and I'm not denying that, Mr. Basu, but I hope to stop being a trustee very soon.
well, that is certainly not borne out in the facts, because there's nothing within the subsequent conduct which suggested that he said he no longer wished to be the trustee. There's no hint or suggestion that he went to any of the individuals concerned and said, well, look, I just don't want to be the trustee anymore, thank you. What he did subsequently was deny that there was a trust at all. And that I think is relevant in construing what for the moment means. My Lord and Lady, the second fact relied upon by the judge is also contained in paragraph 139, which is at page 135 of the judgment, where the judge found that the appellant received the sums as repayments of the loan, and that it follows that he received the shares without making any capital investment. Now, your lordships and ladyship will no doubt be aware that when JEL started its operations and acquired the Laurels nursing home, the money that it used in order to make that acquisition and operate was a £133,000 loan from the appellant, a £266,000 loan from the first and second respondents, and then the remainder funded by way of mortgage. And the point that the judge relies upon here is that the loan provided by the appellant was subsequently repaid in part. And he says it follows that he received the shares without making any capital investment. Now, with respect to the judge, it's in a logical step to say that the repayment of an interest-free loan many years later necessarily means the appellant received his shares in 2007 without making a capital investment. But that submission I'll develop because that forms a subject matter of ground 2. For these purposes on ground 1, I'd submit that even if one accepts the judge's conclusion that the appellant did not provide any capital investment in exchange for his shares, that does not provide cogent evidence as to his intentions. At most, it provides factual context. Now, this comes back to the question my Lord Justice Jackson asked me at the beginning of this appeal, and when I took you to the decision in Gani. And if you wish to remind yourself, it's tab 17 of the authorities bundle, starting at page 243. And there, Lord Briggs notes that where there's a gratuitous transfer, the court first looks to written declarations of intent, which he describes as generally decisive, and in default of that, the court then looks for evidence from which there's common intention to be inferred, which includes the statements before, at, and after the transfer, the party's conduct, and the factual context. So I readily accept that the judge was entitled to have regard to the fact that there were no capital contributions made by the appellant to JEL as part of the factual context. But that was only one piece of the puzzle. And in this regard, I would submit that the option agreement is of significant importance. Before I take your lordship and ladyship to it, I'll explain that it's of importance for 2 reasons. First, it is a document signed by both the appellant and the second respondent, both the shareholders in JEL. Insofar as it addresses questions of beneficial ownership of the shares, it therefore represents the views of both those parties. The judge further found that Mr. Thind had read it and understood it at the time, although he also wrongly recorded that Mr. Thind signed it. It was Mrs. Thind who signed it. And that's paragraph 73.3 of the judgment. Secondly, of all of the documentary evidence in this case, the option agreement is the most proximate to the putative declaration of trust having been executed in 2011. So whilst it does post-date the declaration, it is more proximate than, for example, the for-the-moment comment and other facts and matters upon which my learned friend relies. The option agreement can be found in this supplemental bundle, tab 32. At page 411 of the bundle, you will see that clause 1.5 records that the appellant owns 100 shares in JEL. So there is no mention of trusteeship here, simply ownership. Clauses 2.1 and 2.2, in fact, may be helpful for your lordships and ladyship to read those before I make submissions on them. So you'll see that clauses 2.1 and 2.2 provide a cross option in the event of one of the shareholders' death. Clause 2.1 provides that the deceased shareholder's personal representatives would have the option of selling the deceased shareholder's shares to the surviving shareholder, and clause 2.2 provides a cross option that the surviving shareholder can require the deceased shareholder's personal representatives to sell the shares. Those provisions are entirely inconsistent with any intention by either the appellant or the second respondent that the appellant hold the beneficial interest in the shares on trust for his grandchildren. If he had that intention, and if he did in fact in 2011 hold those shares on trust, there would be no justification whatsoever for the deceased's personal representative, Mr. Gill's personal representative, having any decision-making power over the fate of the trust. When the appellant died, a new trustee would have to be appointed, and the shares axiomatically would not fall into his estate. Further, if the appellant were a trustee, one can see no justification for granting to him an option, if he outlived his daughter, to personally acquire 2/3 of the shares of the company. Moreover, if he held the shares on trust and he died, it would be up to Mrs. Thind as to whether or not she exercised the option to force the personal representative to sell those shares. That again is inconsistent with holding shares on trust. The grandchildren may well not have wished the shares to be sold for the value ascribed under clause 3 of the contract. They may have wished to retain the shares. It's similarly difficult to envisage how it could be justified to provide effectively a negative pledge under clause 5.1, which your lordship can see at page 413 at the bottom. Now, as a matter of construing this document, the judge agreed with these propositions. At paragraph 74 of the judgment, which is at page 125, he said that the 2011 option makes very little sense if Mr. Thind thought that Mr. Gill held the shares in JEL on trust. If, however, he believed that Mr. Gill held his shares beneficially, then the document makes more sense. Moreover, you can see from the preceding paragraphs 72 and 73 that Mr. Thind had attempted to justify the option agreement in his oral examination on a number of grounds, and those grounds were rejected by the judge. The judge also found at 73 subparagraph 2 that it was improbable that the financial advisor who drafted the cross option would have drafted a put and call option if he had been asked to draft a trust deed. So not only did the judge reject Mr. Thind's evidence that the cross option was effectively drawn up in an attempt to record the trust that had been established a few years earlier, but he also found it improbable that the person who prepared it was asked by Mr. Thind to prepare a trust deed. Yet having made those findings, as my lady said earlier, the judge then found that the cross-option agreement did not outweigh the other factors that he had identified within the factual matrix. Now, I would submit that that decision is not just surprising, but is wrong. Lord Briggs and Ganney observed that a written declaration of interest will generally be decisive in to the party's subjective intentions being irrelevant. Although this was a few years after the putative trust was established, it is the closest written record we have. And it's hard to discern how a document that provides that the appellant owns the shares cannot be considered a declaration of his interests, particularly where that document is signed not only by the appellant, but also the second respondent, the other shareholder in the company.
Can you say anything more about what this 2011 option document was actually for? I've understood that Mr. Thind gave explanations of what it was for, which the judge then rejected. But what was the judge left with as to the purpose of that document, if we are considering your argument, which is, I think, that it's the best evidence?
Yes. Well,
what was the document actually for in the judge's estimation when one clears out things that he rejected?
Well, my lord, the judge doesn't really in the judgment come to a conclusion as to what the document is for. I can tell your lordship what I submitted in the court below, which is that it makes complete sense if Mr. Gill is the beneficial owner of the shares, and everyone assumes that he predeceases his daughter.
Yes.
Because what it ensures is that the ownership of the company is then not, 1/3 of the ownership of the company is then not transferred to Mr. Gill's heirs. It's kept within the Thind family. And certainly the evidence that was given by Mr. Thind was that there were frictions between himself and an individual named Kuldeep Gill, who is Mr. Gill's son, and who is Mr. Gill's heir under his will at that time, and continues to be. And so when you look at that factual matrix, one can see that it's entirely justified in the sense that it ensured that the company did not fall into Mr. Kuldeep Gill's hands. 1/3 of the shares didn't fall into his hands in the event that Mr. Gill predeceased his daughter.
So does the reasoning run in this way, that it's not sufficient for the judge simply to reject Mr. Thind's explanations, various explanations? It was incumbent upon him to, particularly when overruling that piece of evidence as showing the true position, to give his explanation of what that transaction was for.
My lord, yes, I think that the judge would have been much better to have done that. But I don't think I need to go that far, in the sense that irrespective of what this document was intended to achieve, and indeed this appellate court doesn't know, because it isn't set out in the judgment, irrespective of what this document was to achieve, nonetheless, this document has at clause 1.5 a written declaration signed by the appellant and the second respondent that the appellant owns the 100 shares. And I rely on the operative terms of the agreement purely to allay any argument that the declaration of ownership of those 100 shares could in some way be construed nonetheless that consistent with him holding them on trust. Because when you combine that declaration of owning the 100 shares without any reference to him holding them as trustee, combined with the fact that the operative terms of the agreement are completely inconsistent with him holding them on trust, I would submit that this is a written declaration of his interests in those shares.
Well, I thought I understood you to accept that this was a piece of evidence, and not that it was, and therefore that it wasn't conclusive.
My lord, yes, I I concede that this is not decisive, in the words of Lord Briggs, in the way that it would have been had it been dated November 2007. Because it's not a declaration of intent at the time that the transfer took place.
Are we not also in danger of island hopping, in the sense that I understand the test that you say applies, but nevertheless the judge had to look at all the evidence available to him, and I dare to use the word evaluate that evidence, when then you say applying the objective test of whether there was clear evidence of the declaration of trust. But he had to look at it all together, and you're picking this out. And for example, if you go back to the judgment, and you started off at 139 and the matters that he does take into account, he also takes that into account in the light of the matters at 140, and deals with the option agreement separately at 141. He's looking at everything in the round, and so we have to be careful not to island hop, but to see in the context of everything he had whether the test was satisfied. I think is what you want us to do, but I'm fearful that you're taking things out of the mire.
I'm attempting not to take them out of the mire, but I entirely agree with your ladyship that one does not look at any one piece of evidence relied upon by the judge in isolation.
No.
And indeed, I believe that was a point that my Lord Justice Arnold made earlier today.
Yes.
And I entirely agree with that. Now, I don't agree with the proposition that this court needs to go beyond the facts identified by the judge as those relied upon by him in coming to the conclusion. The judge has identified those facts. The option agreement is one of those facts that he did rely upon, but he said that it did not outweigh the other matters. But my submission here, and in fact I perhaps take it more holistically, because effectively the facts relied upon by the judge are at paragraph 139 and 140. And I would submit that paragraph 140 is in fact largely duplicative of the last factual finding of the judge at 139. Because the judge found at 139 that the appellant received his shares without making any capital investment. He then goes on in paragraph 140 to consider Mrs. Thind's evidence on which he placed limited reliance. I'll come back in a moment to explain why that was entirely justifiable. But he believed or concluded that her evidence was supported by what he considered inherently implausible. And what he found inherently implausible was that the Thinds would have agreed to give Mr. Gill a 1/3 share in the business unless he had also provided capital contributions, guarantees, and a substantial role in running the business. So effectively, I would submit that 140 is to a very large extent a similar conclusion in relation to paragraph 139. It has to do with the role Mr. Gill had in the business. And put another way,
And whether there were repayments of loans or dividends.
precisely, whether there were, and it's
And in relation to that, he's also said in 139, if there were dividends, why didn't he declare them to the revenue?
Absolutely. And on this appeal, it's accepted that they were repayments. So the question, the point that the judge is effectively relying upon here is his conclusion that there was no capital investment by the appellant.
Yep.
And that leads him to conclude that the appellant's position is inherently implausible, and that leads to his effectively his conclusion that the intention can be shown, clear intention to hold the matters on trust. So stepping back,
And that also affects what he says at 141
Yes.
about the option agreement, because in the light of those things that he's found, he doesn't consider that they're outweighed by the option agreement.
But precisely, my lady. And so what you have is you have the judge saying that there are effectively two findings of fact in terms of what the appellant said or did. One, that he said for the moment, in response to Mr. Bassey's comment. And 2, that he did not make any capital contribution to the company at the time he received the shares. Those are the 2 facts that he relies upon. And my submission is that those 2 facts are nowhere near sufficient to outweigh a written declaration in the option agreement as to the appellant's and the second respondent's views, intentions as to the beneficial interest in JEL.
So in order to succeed in that, you have to effectively show that, to take my lady's reference to the analogy, that this was such a big island that no reasonable judge could have failed to find that it was, that it predominated in this evaluation.
Well, my lord, my primary submission is not that. My primary submission is that this court can take regard to the facts as found by the judge, the for the moment comment, the fact that no capital contributions were made, the comments that he made on the option agreement, and this court can decide whether that is sufficient to fulfill the objective test, which is the same process I would submit that the appellate courts did in On and Ping and in Wilkinson and North, and indeed in Paul and Constance itself.
Does that not amount to you inviting this court effectively to substitute its own evaluation for that of the judge?
No, this is the court considering whether the facts as found by the judge were sufficient to fulfill the test of clear evidence.
Well, I understand that's how you put it, but what I'm trying to work out is how that sits with your acceptance that what the judge has done is to weigh things in the balance. Because, as you've accepted, on the one hand, he weighs in the balance what he finds in 139 and 140, and on the other hand, there's the option agreement, which he deals with in 141, which weighs on the other side. And you stress, and I understand why you stress, that the option agreement should have weighed heavily. But that's what he's doing, isn't it? He's weighing those factors in the balance, making an evaluation as to where it comes down.
But my lord, that is certainly what my learned friend will submit, I no doubt. But I would say that is actually not right. It's tempting to say that that's the case. But if you look at the cases such as Paul and Constance and On and Ping, and indeed Wilkinson and North, the court is looking at the evidence as a whole, as found by the judge, and deciding whether it amounts to clear evidence. And in some cases, like Paul and Constance, the evidence that was relied upon by the trial judge pointed one direction. And in that case, there was no having to weigh up the evidence for and evidence against. But indeed, in other cases, more like this one, there may be evidence that points for and against the intention of a trust. But I'd submit that shouldn't change the exercise. If the exercise in Paul and Constance was for the appellate court to look at the evidence as found by the judge, facts as found by the judge, and ask itself, does objectively this amount to a clear intention to create a trust? Surely the exercise shouldn't change if there is evidence not just for the trust, but also against. Perhaps put another way, had the decision in Paul and Constance at first instance been decided not primarily on 2 facts, the words, this money is as much yours as mine, and the placement of the bingo winnings into the account.
Well, and thirdly, the interview with the bank manager.
And thirdly, the interview with the bank manager, precisely, my lord, thank you. So let's say that had Paul and Constance not had those 3 factors, but had a 4th factor that pointed against trust, because those 3 all point for trust. and let's say there was a fourth factor that pointed against the trust, that shouldn't change the nature of the appeal. It would be a very odd situation where the court, an appellate court, could reassess a trial judge's view as to whether the evidence amounted to a clear intention to create a trust, when it was so clear that the evidence all pointed one way. But the appellate court was then effectively prevented, subject to finding that the decision was irrational, from reassessing the judge's views when it was insufficiently clear because the evidence pointed two ways. And indeed, my submission is that there is a serious error here in the judge's reasoning, because the judge recognized earlier in the judgment that there was a piece of evidence that pointed against the trust. And this comes back to what is meant by clear evidence. And where you have two pieces of evidence, the for the moment and the no capital contributions, pointing towards trust, but then you have a written document pointing against trust, I would submit that that is virtually necessarily not clear evidence.
And so you're saying in those circumstances where there's a document, it could never be. There could never be clear evidence because there was a written document facing the other way.
I can't possibly go that far, my lady, because Lord Briggs himself in Gani said that a written declaration of interest will normally be decisive. So it won't always be decisive.
You say that, but it's the lack of an explanation for what that document was about.
Precisely.
So in other words, the judge could have, you would concede, have, I don't mean this in the wrong way, but got around the option agreement if he'd said, well, this is what that was for.
Precisely, my lord.
And it shows that it doesn't mean what it says.
Yes, or that actually viewed in the proper context, it is consistent with trust. Or
But as it is, your case, as I understand it just sits there. The judge says that it doesn't outweigh things, but it sits there for what it says.
Yes.
Which hasn't been explained.
Yes, precisely. Now, if my lords and my lady are against me on the submissions I've just made in relation to how this is not simply an evaluative factual test, but is a legal test, and you therefore have to apply a sprint room factual appeal analysis to this, I would say in the alternative that this fundamentally fails that test, or rather the judge's judgment in this regard is irrational. And it's
Are you moving on to ground two at this point?
Well, no, I'm not on to ground two. I'm still, well, it would be, it's expressed as ground one, but it's expressed as ground one on the assumption that your lordship is with me, that it is a legal test. If your lordship is against me on that, I would say that the rejection of the option agreement would amount to an error of fact. My lord, I said earlier that I'd get back to why the judge was entirely entitled to place limited reliance on Mrs. Thind's oral evidence. And I'll just deal with that briefly now. And he explains why he placed limited reliance on her evidence at paragraph 80 of the judgment, which is found at page 126 of the bundle. And if your lordship and ladyship could read paragraph 80.
Yes.
So, my lords and lady, you can see that here the judge outlined that her evidence was that she overheard a conversation but did not participate in that conversation in 2006 about a trust for the appellant's grandchildren, but that she did not overhear the whole conversation. And then the evidence she gave of a direct conversation with the appellant concerned improvements to the nursing home and whether or not to tell her brother-in-law about the appellant's £133,000 loan. So there's nothing about trusts. And so you'll see for that reason the judge concluded that he had to treat her evidence with a degree of caution in this regard. And I would submit that the judge here was perfectly entitled to come to that conclusion and has explained cogently why he came to that conclusion.
What about paragraph 81?
Well, my lord, that is dealing with a trust of JIL.
Yes, but
It's to be a trustee again,
yes.
which presupposes that he was already a trustee.
Well, my
And
lord,
the
yes.
judge accepted that evidence, as we can see from the latter part of the judgment.
Yeah, yes, my lord, but that also has to be viewed in the context of her recognizing that her memory was imperfect.
Well, he accepted her evidence, which included 81, as broadly reliable.
Broadly reliable, yes, my lord. But of course, the judge, unlike the option agreement, where this court now can read the document in every bit of the same way as the judge could, the judge has had the benefit of actually hearing Mrs. Thind, understanding through her testimony the lapses in her memory, which she readily admitted, and he has taken the view that he had to approach her evidence with a degree of caution and place limited reliance upon it. I would submit in this regard that the judge's decisions are entirely...
Well, the judge is very careful in this passage to indicate the parts of her evidence that he did view with caution. I mean, paragraph 86 makes this clear, and he was perfectly seeing the way that the judge went about this. It's perfectly clear that had he also had misgivings about the conversation at Bluewater, he would also have said so.
Well, my lord, yes, I take that point. One must remember, though, that this is in the context of an event that took place many years.
Yes, I understand that, but I just think you have to be careful before putting a complete silk screen of caution in front of this witness's evidence.
No, indeed.
She appears to be one of the few people in the family who tells the truth from time to time.
Indeed, my lord. And obviously the judge's conclusion in relation to Mrs. Thind at paragraph 140 was not that he placed no weight on her evidence, but simply that he placed limited weight. And so when assessing the objective standard, this court obviously likewise should put limited weight on what Mrs. Thind says. But of course that is in the context of a conversation in April 2010, where just over a little year later, in September 2011, Mrs. Thind signed the option agreement.
Could I ask a different question while we're on this topic? It may not matter, but it's puzzling me. In 140, the judge used the date of 2007, whereas, as we've just seen, in paragraph 80, he refers to an initial conversation in December 2005, and then further conversations in 2006. I'm a little puzzled at the moment as to where the date of 2007 comes from.
So the short answer for that is that the date of 2007 comes from the company's returns, and the relevant return provided that as at the 27th of November 2007, Mr. Gill held 100 shares. The previous return, it had the sole share having been held by Mr. Thind. It was initially jointly owned by Mr. and Mrs. Thind. It then, and you get this actually from paragraph 10 of the judgment, at page 106 of the bundle. And you'll see that the original annual return of 2004, there was one issued share that was held jointly by Mr. and Mrs. Thind. And then for the annual return in 2006, that share had been transferred to Mr. Thind alone. And then for the annual return filed in 2008, 200 shares were held by Mrs. Thind and 100 by the appellant, as at 27 November 2007.
Anyway, discourteous, my friend, it may help you to know that in this respect, I will accept that 2007, the second line of 140, should have read 2005. I noticed that when I was reviewing the draft judgment, I drew his attention, though I entirely accept my learned friend's point that 2007 will be in the judge's mind as that is when he found that the trust was actually created, because of course you need trust property before the trust comes into existence, and the transfer was indeed 2007. So it's probably good that you know what both sides say about it.
Thank you.
So, my lords and lady, the evidence relied upon by the judge to establish the trust effectively stops here. You have the comment for the moment, you have the factual finding that there was no capital investment, and then there is the limited reliance placed by the judge on Mrs. Thind's evidence. The next paragraph in the judgment, paragraph 141, addresses documents that pointed against the establishment of the trust. And then at paragraph 142, he concludes that the Thind's version of events was plausible, but that, of course, is not evidence of an intention by the appellant to dispose of his interest in the shares. It is merely a finding that it was plausible that he might have had such an intention. So in terms of the words and deeds done and the documents executed, the judge has placed his entire decision on, for the moment, no capital contribution, and then the limited reliance on Mrs. Thind's evidence. With respect to the judge, I'd submit that that evidence is nowhere near sufficiently clear so that a reasonable observer would have concluded that the appellant held the shares on trust for his grandchildren. And you can stress test this against the facts of Paul and Constance, which Lord Justice Scarman expressly observed was a borderline case at page 532D, the judgment. In that case, there was no written document on which the court could rely. In this case, there is the option agreement, which on the judge's own findings pointed against the trust. In Paul and Constance, the words uttered by the putative settler, Mr. Constance, that the funds were as much Mrs. Paul's as his, were clear, unambiguous, and consistent with trusteeship. They were not unclear, as the comment for the moment, and arguably inconsistent, as in this case. Also in Paul and Constance, the putative trustee's subsequent conduct was consistent with the trust. He commingled the funds in the bank account with Mrs. Paul. Of the evidence accepted by the judge, nothing pointed towards any conduct on the appellant's behalf consistent with trusteeship. The closest evidence, I'd submit, comes in the form of a WhatsApp message sent by one of the appellant's daughters, Mrs. Benning, to the second respondent, suggesting that the appellant did say trust for grandkids. But the judge did not rely on that, as it was insufficiently clear and unequivocal. The respondents invite this court to place reliance upon that email in upholding the judge's order. And I would submit there is simply no basis to go behind the judge's assessment of that document, the author of which was not tested in cross-examination, unlike the signatories to the option agreement. But even if this court were satisfied that the WhatsApp was a relevant document, my submission is that it does not come close to displacing the option agreement, especially in circumstances where the WhatsApp was sent many years after the option agreement was concluded and was sent by someone whose children would benefit from the existence.
This is 2019, wasn't it?
2019, yes.
So this is after the balloon went up.
After the balloon went up. And your lordship may recall that the judge effectively said that the family had split into camps. Yeah. And Mrs. Benning was in what the judge described as a Thind's camp. Yeah. And when a court is, and when the appellate court is looking at the decision of the judge, I submit that it can and should take into account other documents and other facts found by the judge in the judgment which are inconsistent with trusteeship. So, for example, there is an email from Mr. Basu, who is the first respondent's accountant, in January 2018, an email which the judge himself said that it appeared to suggest that Mr. Basu viewed Mr. Gill as being beneficially entitled to shares in JEL. And that comment is at paragraph 98 of the judgment. The email is found at the supplementary bundle, tab 34. Page 428. You'll see at the bottom of the page, this is an email from Mr. Basu to Mr. Thind. Over the page at paragraph 2, Mr. Basu records a dividend in that year of £13,400, of which the appellant's 1/3 share was £6,600. He goes on to record that the appellant would have no further tax to pay if his other earnings were below £9,400, i.e. within his personal tax threshold. This email is plainly of less significance than the option agreement, since it's an email from Thind's personal accountant into which the appellant was not copied. It is not a document signed by the two shareholders themselves. However, there are 2 points to be taken from this. First, that Mr. Basu considered that any dividend declared by JEL would be taken by the appellant beneficially. Otherwise, his personal tax allowance would be irrelevant. And secondly, there is no evidence before the court, nor any finding by the judge, that the appellant accounted for any dividends declared to the alleged beneficiaries of the trust, both points being inconsistent with trusteeship. There is a further similar email from Mr. Basu to RBS in August of 2018, found at tab 35 of the supplemental bundle, page 431. And in this email, at the bottom...
I'm sorry, which page are you on?
431.
Thank you. I was reading further into the email. Thank you.
You'll see at the bottom of this email, Mr. Basu mentions another company, Simicare, and he describes that the shares are held in a bare trust by Mr. Gill for the benefit of Mr. Thind's children. But earlier in the email, where he refers to Jeeves Estates, he describes it as a company owned by Mrs. Thind and her father, the appellant, in the ratio of 67 and 33%. No mention of a trust. Now, the judge addressed these emails in the judgment at paragraph 99, which is found at page 129 of the core bundle. He records that Mr. Basu, in cross-examination, sought to justify these emails by reference to what he thought would be accepted by HMRC. And at paragraph 100, the judge rejected that evidence as unsatisfactory. Yet when he came to assess the evidence in relation to JEL at paragraph 141 of the judgment, he did not address the August email at all, and like the option agreement, without further explanation, said that the January email was not sufficient to outweigh the other evidence. Thus, whilst these emails are not important, like the option agreement, they are significantly more probative than the WhatsApp message relied upon by my learned friend. Not least because the author of these documents was available for cross-examination, and his explanations for their terms was rejected. Thus, unlike in Paul and Constance, there is a written document evidencing the parties' intentions which points to against the trust. The words uttered by the putative trustee are on the judge's own findings unclear, and the party's subsequent conduct is inconsistent or at least inconclusive. If Paul and Constance was a borderline case, the present case comes nowhere near the standard required to establish the requisite clear intention on the appellant's behalf. I now will turn to the grounds 2 and 3, which are the factual appeal. And as I mentioned, if the court is satisfied that the judge erred in his conclusions regarding the appellant's intent based on the foregoing ground 1, grounds 2 and 3 do not arise. These grounds are only relevant if the court agrees with the judge that by the narrowest margin the facts as established by him are sufficient to establish a clear intention to create a trust. Your Lordship and Ladyship will be very familiar with the high hurdle an appellant faces in relation to appeals of fact. I will not go into them in detail. However, I would submit this is one of the rare cases where the judge erred on grounds of inconsistency and failures of logic. The first point can be taken shortly. My submission is that he was inconsistent in finding that the words "for the moment" supported his findings that the appellant intended to hold his shares on trust. I've already outlined my submissions as to why those facts are inconsistent with trust. His finding is also inconsistent, I would submit, with his earlier finding that it was not clear what the appellant meant. Secondly, the judge found that it followed from the fact that an interest-free loan provided to by the appellant to the company when his shares were allotted to him was subsequently paid, meant that he had made no capital contributions to the company. And that is from the passage you've already read at paragraph 139. And my submission is that that is an error of logic. You've also seen the passage and the judgment where he explains that when the company was incorporated, the sole share was allotted to Mr. and Mrs. Thind jointly, and that was subsequently transferred to Mr. Thind. And thereafter he transferred that share to Mrs. Thind and caused a further 199 shares to be allotted to her. And so she held 200 shares, as she still does, and Mr. Gill was allotted 100 shares from the company so that he held 1/3 of the shares. It is therefore common ground that the funding of the company was not on the basis of equity capital contribution. Neither the Thinds on the one hand or the appellant on the other hand paid a share premium for the acquisition of their shares. Their capital contribution in equity was limited to the par value of the shares. Instead, the company was funded by way of two loans, a £133,000 loan from the appellant and a £266,000 loan from the Thinds, along with bank financing. That meant that both the Thinds on the one hand and the appellant on the other contributed funding to the company albeit by way of interest-free loans, pro rata to the size of their shareholding, 1/3, 2/3. Now, my lords and ladies, you'll have seen in my skeleton that I cited the tax case of White and Commissioners, and this is found at Authorities Bundle, tab 19, page 284, paragraph 53. Citing a decision from 1908, Mr. Justice Marcus Smith and Judge Richards observed how money lent to a company by a person who is not in the business of money lending would be treated as a capital contribution, and thus, when not repaid, a capital loss.
Where is all this going, in a sense? Is it terribly important whether something's regarded as a capital contribution or a loan? I mean, in this case, this whole thing was launched on loans.
Yes.
And so, do we need to go down this?
Well, my lord, this is
this byroad. I mean, let's suppose it had in this family been considered that babysitting was good enough.
yes.
In that case, if that's what the family thought, then babysitting's good enough.
Well, my lord, I rely on this solely for to make good this point, which is that the judge does not appear to have considered the fact that it was a loan per se, or I'd submit the judge couldn't have considered the fact that it was a loan per se as being the reason why Mr. Gill did not provide any capital contribution to the company, because that is how the capital was introduced to the company by both sides. And what he appears to have decided at paragraph 139 is that it was not the nature of a loan that was the decisive point. It was the fact that the loans were later repaid. And you get that from the wording of paragraph 139, where he rejected Mr. Gill's attempt to blame Mr. Povey for not including the repayments as dividends in the tax return. And he found that he received the sums, that is the repayments, as repayment of loans. He then goes on to say, it follows that he received the shares without making any capital investment. So there are 2 points I say there. First of all, a loan can be a capital investment.
I'm only just querying, what does it matter whether it's a capital investment? I mean, clearly it was an investment in the business. Even if it was a loan, it was... It depends what you mean by investment.
Well, it depends what you mean by investment, but my lord, that
you
is...
don't have to show that there was an investment in the business.
Well, my lord, you'll see that the decision, particularly at 140, where he says the judge finds that it was inherently implausible that the shares were effectively gifted to Mr. Gill, is predicated on the failure of him to provide capital contribution, 1/3 of the capital contribution. Now, my submission is that that is simply wrong, because he did provide 1/3 of the capital contributions at the time he took the shares. He provided the $133,000.
Right, for good measure, you say that in tax law that amounts to an investment in the company.
Well, that is an investment in the company. That is whether I cited the tax case simply to show that as a matter of law it can be treated as an investment. It effectively showed that investments can take 4 different forms.
Yes.
And
we're not concerned
case,
with whether it's an investment as a matter of law. We're concerned with what it means as a matter of fact.
Well,
that's your main challenge to this part of the decision.
Well, I'm challenging his finding of fact that the appellant made no capital contributions to the company. And fundamentally, that, I submit, is wrong, because it is common ground that the appellant did provide 1/3 of the loan capital to the company. And I would heartily agree with your lordship that that is an investment, and that's plainly an investment. And I would go on to say that the mere fact that that loan was repaid some years later cannot change the character of what that was at the time he received his shares.
But do you accept that paragraph 140 is much wider than that, and there are other factors which he's taking into account?
There are
which include the failure, or I wouldn't put it in terms of failure, but the fact that Mr. Gill did not provide a 1/3 contribution for the extension of the laurels, for example. There were no personal guarantees, and he didn't take part in the running of the business. So the point that you're making, if it's a good point, is only one of the elements which are taken into account in paragraph 140.
My lady, yes, it is one of the elements. But insofar as the court is with me that he was wrong to find that there was no capital investment at the time the shares were issued, it's very difficult to see how the subsequent conduct could change the matters. It's also difficult to see how it could be inherently implausible that an individual who provides 1/3 of the working capital and receives 1/3 of the shares, then necessarily it's entirely implausible that he owns those beneficially, because he then subsequently doesn't provide a guarantee where the majority shareholder does.
Yeah, but at the time that he made the loan, he wouldn't have known whether he was ever going to get the money back.
Precisely.
I mean, as it happens, seems things went well enough that he was repaid.
Precisely.
But that could have been lost money.
It could have been lost money. It could have been lost money.
Yes. Right, point taken.
So the first 2 points I've gone through are the for the moment and the finding that there was no capital contribution. The third point is there are a number of examples of evidence which were, in my submission, plainly of probative value, in relation to which the judge gave no weight. And a few of these examples I've already gone through. One is the example of the August email from Mr. Basu to RBS, which, unlike the January email, he makes no mention of in paragraph 141. And a further example is another email from Mr. Basu to Mr. Thind, into which he attached a document recording a meeting with Mr. Thind, a document which has become known as the Portfolio Review. And this email and document can be found at tab 33 of the supplemental volume. Page 415. You'll see here that Mr. Basu sent this email to Mr. Thind, and in the second paragraph says, following on from your meeting on Saturday, please find attached my report summarizing our discussions and includes my observations and thoughts to go with it. And then over the page, or 2 pages, at page 417, you see the start of the document. And you can see that he lists the various companies involved. The first one is Jeeves Estates. If you then turn further into the document at page 419, bottom of the page, you'll see that he addresses Simicare. And over the page, you'll see that he asks questions as to other shares held in trust by Mr. Gill on behalf of the kids. Do you have any trust documents to this effect? The trust has received dividends, etc. So you can see here that there must have been a discussion between Mr. Thind and Mr. Basu about a trust of the shares in Simicare. Then on the same page at the bottom, paragraph 7, you'll see that he addresses Jeeves Estates Ltd. And he says in little a, if I remember correctly, 33% of the shares are owned by Mr. Gill, and these shares are not held on trust. Is that correct? So this document purports to record discussions at a meeting between Mr. Basu and Mr. Thind, and on its face suggests that Mr. Thind told Mr. Basu at that meeting that the appellant held the shares in JEL beneficially. The judge at paragraph 95, however, placed no weight on this document since Mr. Thind did not reply to it. With respect, that is a non sequitur. fact that Mr. Thind did not respond to this email, answering Mr. Basu's red highlighted question to him and correcting Mr. Basu's misunderstanding is not a reason to place no weight on the email. In fact, I would submit it is a reason to place greater weight on the email. Any objective bystander having regard to this email would come to the conclusion that Mr. Thind agreed with its content because he did not respond, correcting Mr. Basu. My lords and lady, I would submit the issue goes even further than that.
This is the no denial point.
No denial, yes. Because the judge, and I believe my Lord Justice Jackson probably has my next point already in mind, because the judge earlier in the judgment specifically rejected Mr. Thind's explanation for not responding to this email. So this is at paragraph 68 of the judgment, page 123.
Sorry, that's accepting the relevant evidence, isn't it? Because the point that's foreshadowing is what he says about the option agreement. He accepts that Mr. Thind had little time for paperwork which was of no obvious benefit of, e.g. confirmation sought by Lloyds or Mr. Bassett.
Well, my lord, this is not, I'd submit, an email for compliance purposes. This is an email substantively looking at the question of trust. But I take your lordship's point.
Well, you would say it's an email which, if left uncorrected, is detrimental.
Yes, precisely. And indeed, it would be very much to Mr. Thind's advantage to answer that and correct the position so that steps were not taken on the wrong understanding by Mr. Basu.
Well, I take your point that there's no response saying this is wrong. But then there's no response at all to any of the questions.
No. None.
So what do we get out of that?
Well, my lord, certainly.
Does that not tend to support the proposition that Mr. Thind didn't think this was of any importance and therefore he simply ignored it?
Well, the other questions, for example, in relation to Simicare, those shares were held on trust for the children, and that is part of Mr. Thind's case. My lord, a further example of the evidence that was rejected by the judge, which was probative to this question, is given at paragraph 53 of the appellant's skeleton argument. And this concerns the transfer of WHL into the JEL company structure. Effectively, the point is this, that Mr. Thind's own evidence was that he didn't particularly take notice of the fact that a company called Watts Healthcare Ltd had been transferred into JEL. Now that is consistent with Mr. Gill's case, that he was a 1/3 participant in the Sherwood nursing home, which was operated by WHL, having provided it's common ground, a £280,000 loan towards it. And that then brought that business within the structure of JEL, of which he was a 1/3 owner. But it is inconsistent with the shares in JEL being held on trust. Because by bringing the WHL company into the umbrella of JEL, making it a wholly owned subsidiary, that effectively constituted a further gift by Mr. and Mrs. Thind to Mr. Gill's grandchildren. it is simply inconsistent, therefore, that Mr. Thind had no particular regard to that becoming part of the JEL structure, given that on his case it would have had significant consequences in expanding the gift.
Can you remind, the 280,000 was paid by whom and when?
So the £280,000, and I can get the references in the judgment, is paid by Mr. Gill towards the development of a new nursing home called Sherwood. And Sherwood was in fact bought by a pension fund, which is for the benefit of the Thind family.
What was the date of the payment?
The date was... so this is, if you want the reference, this is starting at paragraph 28 of the judgment, page 111.
Thank you.
And it's common ground that this is paragraph 30, common ground that Mr. Gill transferred £280,000 to WHL in 9 instalments between November 2012 and November 2014, and that he received back £50,000 in July 2015 and £200,000 back in December 2016. The appellant recognises the high hurdle faced by him in any factual appeal. However, it's submitted that this is one of those rare cases where the judge simply came to factual conclusions that were inconsistent with earlier findings and involved leaps of logic that simply cannot be justified. And this is also a rare case where very fine points on factual matters are of real significance. The judge himself acknowledged that he found it more difficult to determine the questions relating to JEL, and he also expressly expressed his conclusions on terms that he decided it on by a narrow margin. That's paragraph 143 of the judgment. In those circumstances, it is submitted that if the appellant is successful in establishing that the judge erred as a matter of fact in relation to just one of the identified issues, the judge's entire factual determination is rendered unsafe, because it tips that balance of that narrow margin. Against that, the respondents have identified 3 factual matters that they consider the judge ought to have provided greater...
So we're on to the respondent's notice now, are we?
On to the respondent's notice, my lord, yes.
Thank you.
And I can obviously address these to a greater extent in reply, so I'll just make very brief comments now. Both grounds 1 and 3 for the grounds of upholding the order, the respondent's notice, concern the weight that the judge ascribed to oral evidence in relation to Mr. Avnish Thind, who is the Thind's elder son, and Mr. Satnam Singh, Mr. Thind's father. And I can give you the references. In relation to Mr. Avnish Thind, the judge observed that his understanding of the trust arrangements largely derived from his parents, and thus did not significantly advance the case. And that's paragraph 87 of the judgment. And where Avnish could give direct evidence as to what the appellant said, he acknowledged that, quote, he could not recall the exact words used and that he did not understand at the time what a trust arrangement was, unquote. And these are all reasons the judge properly acting could decide to give this witness evidence no weight. Regarding Mr. Satnam Singh, Mr. Thind's father, the judge observed that his evidence was simply that of what he had been told by Mr. Thind. Mr. Thind's father, the judge observed that his evidence was simply that of what he had been told by Mr. Thind. And you can see that from the judgment at paragraph 111. And I'd submit in circumstances where the judge had found that Mr. Thind had been dishonest and that his evidence was untruthful and could not be relied upon, the judge's decision to ascribe no weight to second-hand evidence of what Mr. Thind had said to his father cannot be faulted. And then that leaves ground 2, which concerns the WhatsApp message sent by Mrs. Benning, and I've already addressed your lordship's committee on that. This finally leads me to the resulting trust. And this concerns the judge's alternative finding that in the event he was wrong as to the appellant's intentions to create a trust, he nonetheless held the shares on resulting trust for the Thinds. And that is paragraph 145 of the judgment, found at page 137 of the bundle. As a preliminary observation, if the appellant is successful on ground 2, as to the judge's decision that the appellant provided no capital contribution to the company, then the finding in respect of resulting trust must fall as well. And this is because you'll see that the resulting trust is said to have arisen because the Thinds alone provided the capital for these companies. So the factual basis upon which the judge identifies for the resulting trust is that the appellant did not provide any capital investment in the company. I've already addressed why that is wrong, and if that is wrong, the resulting trust analysis must fail. However, even if the judge's findings of fact stand in relation to the capital contributions to the company, but his decisions as to the appellant's intentions are overturned, his resulting trust analysis, I would submit, is flawed. First, this cannot be a form of resulting trust arising from the failure of the trust, because the alternate analysis is only relevant if the requisite intention to form and express trust in the first place does not exist. In other words, this is not a case where it was intended to create a trust, but due to some technicality, it didn't work, and therefore the assets result to the settlor. The judge's analysis is only relevant if there was never an intention to create a trust in the first place. Moreover, even if that were wrong, the appellant would be holding the shares on trust for himself.
Sorry, can I just see how far you go with that? Because I think I understand the point you're making, but do you say the judge ought to have found that there was a gift?
Well, my lord, no, the judge ought not to have found that it was a gift. And in fact, I'll get to that, because that is effectively the second basis upon which a resulting trust might arise. I am simply I'm approaching this from the basis that there are effectively two ways for the resulting trust to arise. One of which is that there was an intention to create a trust, but it failed, and therefore it results back to the settlor because of the failure. The second way would be a resulting trust where effectively there is a gift, and if the court presumes that there was no intention to give, and instead the donee should hold on trust for the donee. So I'm only addressing that first form of resulting trust, which arises on the failure of a trust, in the submission I just made. And just to finish my points on that, that even if I were wrong in respect to the first submission, the fact is that if this trust failed and the assets were held on trust for the settlor, it would necessarily mean that the appellant would hold the shares for himself, because he was the settlor. And indeed, that is the very basis upon which the judgment is predicated. It's his intention to create the trust that he is the settler. But secondly, and this goes to the other form of resulting trust, which is a resulting trust in the form where the settler failed to part with the full beneficial interest in the property, or the donor failed to separate from the full beneficial interest of the property. Now again, the appellant was the settler, so any beneficial interest in that regard would reside with him, not the Thinds. And indeed, the Thinds never had any beneficial interest in these shares. They were allotted to the appellant by the company, not transferred to him by the Thinds. Now, in that regard, my learned friend relies upon the decision in Shepherd and Cartwright and Fanmail to stand for the proposition that the Thinds, as persons who caused the shares to be allotted to Mr. Gill, can benefit from the resulting trust. But with respect, that is a misreading of those judgments. And this point can be made by reference to the decision in Fanmail, which also considers Shepherd and Cartwright. And Fanmail is found at Authorities Bundle, tab 10, page 114. So you can see from paragraph 198 that in that case there was a company, Fan Mail, which caused another company to be formed, DPL. And Fan Mail instructed...
Where are we reading from? Yeah. Where have you taken us to?
Page 114.
So page 114.
114, thank you.
And in fact, it's 196 to 198 explains the factual background, which is that the company Fan Mail caused another company to be formed, DPL. And then Fan Mail instructed the accountants to issue 4 shares in DPL to various individuals. And the shares at the time they were issued were not paid up. And you can see that from paragraph 198. And Fan Mail argued that the 4 individuals held the shares on resulting trust for it by reference to the decision in Shepherd and Cartwright. And you can see that recorded at paragraph 200. At paragraph 201, the judgment records that counsel for the individuals who held the shares observed that the promoter in Shepherd and Cartwright had paid for the shares that were issued by subscribing for them in cash, whereas Fan Mail had not paid any subscription monies. It was also noted that the individuals, whilst not having paid for the shares, nonetheless became liable to contribute the par value in respect of each share when called to do so by DPL. At paragraph 202, Mr. Justice Sales agreed that the key fact in Shepherd and Cartwright was that the subscriber had paid for the shares issued to the third parties. And he further concluded that consideration had been paid by the individuals in the form of their personal liability to pay DPL the par value when called to do so. So pausing there, for the same reason, Shepherd and Cartwright, I would submit, is of no assistance in this case, since there is no suggestion that Mr. and Mrs. Thind paid for the shares allotted to the appellant. The appellant also, at the very least, was liable as a shareholder in the same way as the shareholders in Fan Mail, and that counts as consideration. Now, it is right at paragraph 203 that Mr. Justice Sales continued and observed that that was not the end of the analysis, because the subscription monies of £1 per share were tiny, as he says, in comparison to the true cost of incorporating DPL. Costs which, on the fact of this case, Fan Mail, were borne by Fan Mail. And it was in that sense that Fan Mail had paid for the shares issued to the individuals. Now, I'd submit what is gleaned from both Shepherd and Cartwright and Fan Mail is that for a resulting trust to arise in favour of Mr. and Mrs. Thind, the court must be satisfied that they paid for the shares issued to the appellant, either in the sense of subscription monies, as in Shepherd and Cartwright, or some other costs, as in Fan Mail. And I would submit that this is also consistent with the Supreme Court decision in Prest and Petrodel.
Well, just before you get on to that, what do you have to say about what Mr. Justice Sales said in paragraph 205? Particularly, I think it's the third sentence, whether a resulting trust arises or not, is based on the court's assessment of the true or most likely objective intention to be ascribed to the parties to a transaction involving the acquisition of property as to the ownership of that property based on a factual presumption taken to arise from the identity of the person who pays the property. And then he makes the point it's a rebuttable presumption.
Well, my lord, in that regard, I'd say two things. First of all, the resulting trust in this case obviously arises where the intention to create a trust doesn't exist. But also, secondly, and this is really my core point on this case, is that Mr. Gill did pay for these shares, necessarily. Not only because he signed up to be liable for the par value, but because also it is uncontested that he contributed £133,000 towards the capital of the company. Now, whether that counts as an investment or whether that counts as capital, doesn't really matter for these purposes, because the fact is he provided an interest-free loan to the company, and then he received shares. And it's very difficult to say in those circumstances that it's akin to what happened in Shepherd and Cartwright or fan mail, where effectively the individuals concerned, the shareholders concerned, truly got their shares for absolutely nothing. At the very least, Mr. Gill forwent the interest that he could have charged on that loan for the period until it was paid off. So this is not a case where you can say, one, that Mr. Gill received the shares for nothing, or two, that in any meaningful way Mr. and Mrs. Thind paid for those shares on his behalf.
Thank you.
My lord and lady, unless I can assist you further, those are my submissions.
Were you going to look at Preston Petri de la Hall?
I was only going to make the point, and I don't need to take your lordships to it, which is that in Preston Petridel, necessarily the focus was upon who funded the acquisition of the properties in question. And your lordship will be very familiar with the facts of that case. The key element there was that it was found that the companies that were the registered holders of the property didn't pay for the property, the husband did. And that is entirely, I'd say, consistent with the approach the court takes in this regard on resulting trusts. It's a question of whether or not the individual who is said to be the trustee, the resulting trustee, effectively got the asset for nothing.
Well, good timing, thank you, Mr. Lilly. Mr. Arnold, we'll hear you at 2 o'clock, and possibility of finishing today seems to be an open one at this stage, does it?
Open, Lord, yes. Obviously, I will gleam when I'm pushing an open door and gleam when I've got work to do.
Thank you very much.
All right, available.
No, actually, the best thing for it is extending